Good afternoon, everybody, and good morning to our friends on the West Coast. We will be starting here in the next 60 seconds. Thank you for joining us today. Thank you, everybody. I'm Rob Beatty. I'm with C.O.R.E Group, and today we are going to talk about legacy planning. Today's presentation is the first of two. Today is what I call Legacy Planning 101 or Estate Planning 101. Um, we like to refer to it as legacy planning as opposed to estate planning. And why is that? Most people, when we talk about estate planning, all they're thinking about is estate taxes, how to mitigate estate taxes. Well, as of January 1, 2026, a married couple will have $30 million in lifetime exemption, lifetime gift exemption, lifetime estate tax exemption, and lifetime generation skipping tax exemptions. Less than 1% of the population will ever be affected by estate taxes with a $30 million joint lifetime exemption. So we refer to it as legacy planning because it's about legacy. For me, the primary question that we raise with regards to legacy planning is, does more matter? If you could do more for those you care about, family, community, charity, would you? And that for me is the heart of legacy planning. But for me, there's also two aspects of legacy planning. There's the mechanics of it, or the things that everyone should do. And the things we're going to talk about today, the things we talk about today, if you have any assets that exceed your state's probate limits, you ought to be doing this type of legacy planning. And even if they don't exceed those limits, we'll get into why it's important to do this type of legacy planning we're discussed today. The second phase and the second presentation that we will do on legacy planning is going to deal with, okay, if more does matter, what are the strategies that you can do to pass more on more efficiently to those you care about? So an introduction to estate planning, the process of arranging for the management and distribution of your assets during life and after death. Because again, when it comes to legacy planning, most people also think, well, it's post-death, and it's not. Uh, Good legacy planning starts years before any type of death or uh, disabling event where the person becomes incapacitated. And what's the purpose? To protect loved ones, minimize taxes, avoid probate delays, and ensure your wishes are honored. How many times have we heard about, and that's the other thing is most people, so when you're dealing with your semi-affluent, affluent, and ultra high net worth clients, most people assume, well, they got a fortune. They must have already done all of this planning. And it's important to ask every time, how many times have we heard about some billionaire that passed away intestate, or the last time they reviewed their estate plan was 30 years ago when they drafted it and they weren't billionaires, or no one really knows what their wishes were and it gets tied up in courts between the interested parties trying to divvy up the assets of the estate. And you don't even have to be a billionaire. We've got a case right now where the total assets involved are $1 million, and the three siblings are tearing each other apart about $1 million, and that could have been avoided with some decent legacy planning, the type of planning that we're talking about today. So I call it core estate planning documents, estate planning 101. I believe anyone who is interested in avoiding probate ought to have a revocable living trust. And why? One, it avoids probate. Two, it protects privacy. Probated estates are public records. Anyone can go to the county records, pull up the cases of the probate court, and see what's going on. Who's involved? Who are the beneficiaries? Where are the assets being? What were the assets? How are they being distributed? Anything that goes on in a probate court is subject to public record disclosure. And it also helps manage assets, a revocable living trust. Should you become incapacitated while you're alive, who do you want to have making decisions for you? What do you want those decisions to be? And how do you continue your affairs? If you become incapacitated, whether it's temporary or permanent, who's going to pay the bills? Who's going to pay the mortgage? Who's going to make sure the insurance premiums get paid? Who's going to deal with the day-to-day aspects of maintaining your life as it was? Again, whether it's temporary or permanent, trusts, a revocable living trust with powers of attorney, durable powers of attorney, medical powers of attorney, where the designated responsible person is named and clearly laid out, so that in the event that something happens and they say who's in charge or who gets to make the decisions here, here's the legal documents. It's all in place. So a power of attorney appoints someone to handle your financial and legal matters. So again, you want durable powers of attorney. And in many cases, when you're, as your parents age and they get older and you're responsible, in my particular case, my mother gave me power of attorney while she was still alive, and even while she was still cognizant and able to make decisions for herself, just as a matter of having a second set of eyes and helping her manage her affairs. And then you have the health proxies and the advanced directives. You're in the hospital, you're incapacitated. Do you have a do not resuscitate? Do you want it? Do you want them to not take extraordinary heroic measures, or do you want them to take heroic measures? They choose, like, no matter what, if you can keep me alive, keep me alive. Put that together, put it in a health proxy. Who gets to make those choices should you not be able to make those choices? And why? Because, to have to go to court after the person is incapacitated or after the person is dead and have the court sort out what your wishes were or what's going to happen to your affairs and to your assets is very costly. It's costly from a time perspective, it's costly from a money perspective, and it's costly from a relationship perspective with your family, the relationships within your family and amongst those you care about. So again, revocable living trust with a pour-over will, with medical powers of attorney, durable powers of attorney, health proxies, medical directives. This is estate planning 101. And again, generally, if you're destitute, you don't need it, right? Bear with me for a second. If you don't need to have those proxies in place, but again, if your estate is not, if you have assets that exceed your state's probate limits, all of these things are valuable to yourself and to your family. So what's the next part of an estate? You need to do an inventory. Just ask yourself this. If the proverbial bus came down the pike, or you just became incapacitated tomorrow, who knows where all of your assets are? Who knows where all of your accounts are? Your bank accounts, your real estate, your investments, what insurances do you have? Last week, or our last presentation was about long-term care and having long-term care insurance and long-term care records. If you have it, no one knows you have it, it's as if you don't have it. If they don't know you have these insurance policies and where they are and what the benefits are, how are they going to know to go file the claims to take care of the expenses that you've been responsible and put solutions in place for? And then it's also about beneficiary designations. When's the last time you reviewed all of the beneficiary designations for yourself and for your clients? We had a case, and I know you've all heard this story before, where the gentleman 25 years before had named his girlfriend beneficiary of his IRA. They split up 20 years ago. He passes away. They go to file a claim on that IRA, and it goes to this woman that he hasn't spoken to in 20 years. Those beneficial designations on IRAs and insurance policies and anything else with a beneficial, they're almost impossible. The courts will not intervene. They're sacrosanct. Why? Because the court's position is that we can't possibly know what was on the mind of a dead person. And therefore, all we can do is follow what the documentation on those accounts says. So beneficiary designations and a review on a regular basis is a valuable part of the estate planning 101 suite. What are some common mistakes? Outdated beneficiaries, failing to assign contingent beneficiaries. You put your spouse on as the primary beneficiary, your spouse predeceases you, then you die. There's no contingent beneficiaries to go to your kids. It's now going to go to your estate. The default is your estate. That can create all kinds of issues. One, particularly with qualified plans, if you name the estate's not a person. So really typically the only option available on qualified funds when the estate is named beneficiary is a lump sum distribution into the estate, and then it's distributed. It's a big failure, right? I mean, even if you can name your kids and give them 10 years to stretch out those distributions if you set up a contingent beneficiary. And also, as I said, not updating your beneficiaries regularly. They need to be checked every 2 to 3 years. When you're having client reviews, has anything changed? Do you want to change your beneficiaries? As part of reviewing your investment portfolio and your IRA accounts for your clients and the insurance products that you've put in place for them, on a regular basis, you should be asking them if anything needs to change with the beneficiaries. And the other aspect is overlooking digital assets. Now, this is a relatively new area, and quite frankly, some of the law about it is just being formulated. But people have a lot of digital assets out there. I mean, just think about crypto coins, right? I mean, yeah. How about the guy in England that threw away a stick that would be worth $1 billion and he's spending the rest of his life trying to find it in the dump? Those types of, where are those things? Where are those assets held? And how does your family get at it? And the other common mistake is assuming verbal promises are enough. Verbal promises aren't worth anything. They're virtually unenforceable. Now, maybe you got lucky and there was a verbal promise and there was a witness or two there that aren't interested parties in that conversation, and maybe they could go to court and maybe they could make the case that there was a verbal contract in place. But why? Why even go there, right? Put it in writing, put it in your revocable living trust, lay out clearly what your wishes are, who you want to get what and when. Don't leave it to chance. Protecting assets and minimizing taxes. So again, another aspect of this type of planning is that if you have a revocable living trust and you become deceased, or you become incapacitated and the trust becomes irrevocable, that irrevocable trust is going to protect those assets for your beneficiaries, for those that you care about, for those that you want to get at, that you want to have and inherit the things that you've acquired throughout your life. One, life insurance is a big part of the strategy. It provides liquidity to cover debt, taxes, and income replacement. So when we talk about enhanced legacy planning, people talk to me, they say, oh, I don't need life insurance. I have enough in liquid assets. Or, you know what? I don't want to pay the premiums. I don't have a need for liquidity. One of the most underrated aspects of having life insurance in a legacy plan is the concept of liquidity. Forget about, oh, we're minimizing estate taxes or we're maximizing this. Just having liquidity at that time when someone dies. You can file a death claim within 30, you can typically get a death claim paid out within 30 days when you receive the death certificate. That's typically how long it's going to take the carrier to get the paperwork out and get the check back to the client. That liquidity on hand immediately provides time for the trustees and for the executors of the estate to get the estate in order and to avoid having to sell assets off or inject cash from other sources into it or borrow money to keep the estate afloat while you settle the estate. the life insurance liquidity is very important key in legacy planning. You need to take a look at gifting strategies. Again, we've got people have a joint couple, they have a $30 million lifetime gift exemption. And if your client's estate, let's say they're worth 10 or $15 million, and even if you grow it at 8% for the next 25 years at their life expectancy, are they going to get to that threshold? They can start moving assets out of the estate today and have all of that wealth accumulate outside of the estate, put it into trusts for their beneficiaries, get it out of their estate. Why? It provides asset protection, and it makes it clear that who you want it to go to and when. So we talk to people about using their gifting today. And the other thing about the gifting today versus 10 years from now or 20 years from now, what is estate taxes going to be 10 years from now, 15 years from now? Currently, the current administration and the current control of Congress, their preference is that if they had their way, they'd eliminate estate taxes altogether. Political winds ebb and flow. Who knows when if that tide turns and all of a sudden we have an administration and a Congress that's looking to tax the rich. What are they going to do to estate taxes? I've been in the business 32 years. Estate taxes have changed 16 times in those 32 years. Just because we have a $30 million exemption today, and again, the reality of it, it's more of an image thing. The reality of it is, even before it went to, even when it was at 15 million for a married couple, most people were never going to pay estate tax. But if you're looking to poke an eye at the plutocrats in our country and make a statement, what are you going to do? The first place you're going to go is try and cut estate tax exemptions and make the rich pay more taxes at death. I'm just saying we've got this unprecedented $30 million window. We should be taking a look at gifting strategies today and getting some assets out of the estate. And then if they cut it back, it's still outside of the estate. It's not going to suck it back in. The other thing we want to talk about is this, and the second phase of our legacy planning is going to be drilling into in greater depth some of the concepts as far as irrevocable trusts. One of the greatest financial planning tools today for legacy planning is an intentionally defective grantor trust. We've got a presentation just on that idea and why it's so powerful. If we're going to have a client set up an irrevocable trust, get assets out of the estate today. Let all of the growth be captured outside of the estate today. So what we like to say is, let's get it out of the estate. Let's get it into an intentionally defective trust. What's an intentionally defective trust? It's a trust that while the grantor is alive, for income tax purposes, it's as if the trust doesn't exist, which means that the tax consequences of the trust while the grantors are alive flows through to the grantor's 1040. And why is that important? One, because trust tax rates hit 40% after the first $15,000 in income. So if you put it in an irrevocable trust and it's not defective, that trust, if it doesn't distribute the gains and the income every year out to the beneficiaries of the trust and are retained, it's got to pay 40% income tax on any of the growth in excess of that $15,000 threshold. If it flows through to the grantor's 1040, effectively the trust grows on a tax-deferred basis. And the grantor doesn't hit the 40% tax bracket, and I'm assuming that there's some degree of state income tax, 37% plus, if you're in New York and California, you're looking at 46 to 50% tax. But you don't get there until you're in excess of, $500,600,000 of income jointly. So it's much more tax efficient to have an intentionally defective trust. The assets grow tax deferred outside of the estate, and the payment of those taxes by the grantor on behalf of the trust, they're not gifts. It's an additional way to transfer wealth out of the estate without using any of your gift exemption. So that's one strategy. Then within that intentionally defective grantor trust, make it a dynasty trust if your state allows it. I found out recently that California, the way their law is currently written, does not allow dynasty trusts. But in many states, for example, in Arizona, I believe the trust can remain in force for up to 500 years. There's some states where they'll allow it to remain in force for up to 1,000 years. And there are a handful of states where, as long as there is a lineal descendant from the original grantor alive, that trust can remain intact indefinitely. So what do? You get the assets out of the estate, and your heirs, your children, your grandchildren, your great grandchildren, they actually never own the assets inside of the trust. What does that do? It provides asset protection, right? I always talk about the Kennedys. Joseph Kennedy put all of his stuff in trusts. Jack Kennedy and Ted Kennedy and Bobby Kennedy didn't own anything. They lived like they owned everything. They enjoyed the fruits of the assets inside of the trust. They enjoyed all of the residences and all of the properties and all of the benefits that the Kennedy family, the Kennedy trust had without actually ever owning any of it. So when they died, there was no estate tax due, right? They don't have an estate. It's all inside of the trust. The trust is perpetual, so it doesn't die. It doesn't pay estate taxes. So if you set up a dynasty trust, it remains intact in perpetuity. Well, effectively, I mean, 500, I'll take 500 years for that trust to remain intact. Um, it's just a great long-term estate planning strategy. And again, we're going to do a second legacy planning to deal with that in greater detail, explain how they work, explain the code, talk about dynasty trusts, talk about life insurance planning and dynasty trusts, and talk about liability protection. So again, what's the biggest benefit of setting up a revocable living trust, doing estate planning 101? It's avoiding probate. That means that once the grantor dies, once the person who has set up this revocable living trust should pass, that trust becomes irrevocable, and then there's a trustee or trustees in charge of the distribution of those assets. My personal experience for both of my parents is that I was trustee of their trusts, and I did not have to do probate for either one of my parents because we had titled everything into it. And that's a very critical part. If you get a revocable living trust drafted, and some law, you get them $2,500, $5,000, depends on the sophistication and complexity of your affairs. If you don't title assets to that trust, you just bought an expensive doorstop. It's a binder, weighs a good 5 pounds. You can use it for a doorstop. You've got to retitle all of the assets that you want governed by that trust to that trust. So your non-qualified accounts, your residencies, any other assets, any other real assets, I would retitle in the name of my revocable living trust. If you don't, they'll be subject to probate. They're going to be driven by what your will says. Now, again, you have a pour over will and it'll dump it in, but you still have to probate those assets if they're not titled to the trust. Now, there are simple ways to bypass this. Transfer on death registrations for brokerage accounts. You can put a transfer on death on just about anything. I know where I live in Maricopa County, you can go and put a transfer on death on the title to your property with the county recorder, and that should be sufficient to avoid probate. But again, I think living trusts are a very powerful tool because, again, in that you get the revocable living trust, and you set up the powers of attorney, durable powers of attorney, medical powers of attorney, all of your medical codicils. You set all of that up in one place, and you avoid probate. And forget the cost of the probate, just the hassle of it. The time that it takes for that trustee to go to court, to get an attorney, to file the documents, dot the I's, cross the T's, go see the notary, all of that mechanics of just carrying out those affairs, it's a pain in the butt. And do you want to do that to the people you care about? Do you want to die intestate and have them spend years trying to sort this out? And again, it's the time, it's the energy, it's the resources to take a chaotic situation and make order out of it. You can avoid that by setting up a revocable living trust and having all of it codified before anything happens to you. Again, transfer on death. If your clients don't want to do the trust planning, I would highly recommend that on all of the non-qualified accounts that you have, that you put a transfer on death in place, because it can minimize those hassles if there's not clear legal directives in place. So, planning for incapacity. Again, it's not just about death. It's about durable powers of attorney. And again, whether the incapacitation is temporary or permanent, you need to have someone that can pay the bills. If you still have a mortgage, someone's got to pay the mortgage. That's one thing I learned in these situations from my personal experiences. Life doesn't stop, and big business doesn't care. They want their money when they want it. And if they don't get it, they get mean. They get grumpy and they start sending threatening letters and threatening foreclosure. So you need someone that can pay the mortgage, that can pay the utilities, that can sort out all the other payments that you have going on in your life. And again, the healthcare directive. If you should be in a hospital situation and you are in a life and death situation, do you want to be resuscitated? To what degree do you want them to try and save your life if your life is in jeopardy? In many cases, if the person's they're cognitively in decline and they don't want to be, listen, if my life is over, please don't wake me up, right? Put that in place, because there are certain times when, if you're in the hospital and the family's like, we don't want to take any heroic efforts, and the hospital says, well, we think we should, and you're not making the right decision, and there's no clear legal authority for the family to make that call, the hospital can go to court. They can get an injunction. They can force you to keep that person alive. We've heard about it in the news. It's not common. I mean, in most circumstances, the hospital is going to make a rational decision, but in other circumstances, they may not. And then again, long-term care planning, insurance or Medicaid strategies. Now, I think everybody on this call would consider yourself a wealth advisor, but there are times where Medicaid planning, which I call destitution planning, I mean, you basically have to plan to go bankrupt before you can get Medicaid strategy. It's not really how we address things when we consider ourselves wealth managers. But getting long-term care insurance in place, making sure everybody knows you have long-term care insurance, what it is, where the policy is, and what the benefits are. But again, planning for incapacity. The amount of people that are facing cognitive impairment as they age, it's skyrocketing. And why is it skyrocketing? Because the number of people that are living older is skyrocketing, right? Life expectancies are expanding, and with it goes the number of people who are living older, but they're becoming cognitively impaired. And there's varying degrees of cognitive impairment, but that's again why the powers of attorney are important and the healthcare directives are important. Family considerations. Guardianship for minors if you have minor children. And who's going to take care of them? Who Something happens to you and your spouse, who's going to take care of your minor children? It's a conversation. And by the way, don't name anybody that you haven't asked and gotten their permission to name to act on their behalf. I've seen it happen, and the other people are like, "You did what?" But guardianship planning is very important for minor children. Special needs planning. So part of our legacy, our second one, is we're going to dive into specifically special needs trusts, how they work, what type of planning should be done with regards to special needs planning. But there's a lot of people out there who have children that are always going to be dependent on someone for the rest of their lives, right? To take care of them, to house them, to feed them, to make sure that they have a quality of life, because they're never going to be capable of doing it themselves. Special needs planning is a great topic. It's a great conversation to have with your clients. We've got great resources for special needs planning. And again, it'll be part of the second legacy presentation. We're going to drill in very deep into legacy planning. Blended families. This is another topic that you hear more and more about, where it's husband and wife. It's their second marriage. Husband has all the wealth. He married his spouse. He's got 3 children from the previous marriage. He says when he passes away, he wants everything to go to his children. The wife came in not as much in assets, and she's got 2 children, and she feels that she wants something, that her children should be entitled to something. All of these issues, man, that's got to be dealt with up front, laid out in the legal documents. Otherwise, it's going to be a mess. If someone should die intestate in that situation, the only people that are going to benefit from that are the lawyers. It needs to be laid out. And there's planning strategies where the spouse with the more assets who wants it to go to their children after they pass, well, they could set up a Q-tip trust, or they could set up uh, a lifetime estate where the surviving spouse still gets use of the assets but doesn't get to decide what happens to those assets after they pass. And then at the second spouse's passing, it goes to the first spouse's heirs, whoever they choose that they wanted to go to. Blended family planning, it's a touchy subject. It requires great discovery and tact when talking to your clients about it. But it's very important with blended families to get it all laid out, because the second thing is that if someone should die intestate and it was a husband and wife and they have two kids and the two kids have spouses and there's grandchildren, the 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 state has clearly delineated who gets what in what percentages and when. You start doing blended families with second spouses, third spouses, children, stepchildren, half children. It gets very complicated and really should be avoided, because the legal defaults for that type of an arrangement just get exponentially more complicated. And then you want to define whose roles and responsibilities. You need to be careful choosing who your executors are, who your trustees are, and who your guardians are. You need to ask them. You need to get their permission to name them. And quite frankly, you need to review that about every 3 to 5 years, because that's going to change as time passes as well. And you need to prepare heirs for responsibilities. So when I say responsibilities, one, the responsibilities of the disposition of the estate. But the second thing is, when you have semi-affluent, affluent, and ultra high net worth individuals, if those children don't know what they're going to inherit, they don't have the financial IQ to manage those affairs, that all of a sudden they're going to get this influx of wealth. I was on a call yesterday with an orphan account that called in, and mom died. Mom had $1 million life insurance policy. And the lady, I'm going to help her file the death claim. She's going to get a check for $1 million. And she's like, I don't understand how this works. And I said, you're going to get $1 million income tax free. I think they're a little stunned. I don't think they're prepared for it. So when we talk about preparing heirs for responsibilities, it's about, one, helping your clients. Okay, what do they want to have happen? And then helping coach your clients, or have the clients bring their beneficiaries in and have an upfront conversation about what the estate looks like. What are the expectations of the parents can control it through the trust, what they want the kids to get or the heirs to get, and when they want them to get it. They can put restrictions in place. They can rule from the grave, but it's important that all of that be documented and that the heirs have some idea of what it is. And if they don't have the financial literacy to manage the type of inheritances they're going to get, it's another opportunity as an advisor to start providing those resources to your clients. And then to delegate decision-making with regards to healthcare proxies and power. Who, you're in the bed and they're deciding whether or not they're going to turn off the respirator. Who do you want to make that call, right? It needs to be laid out. And I know a lot of what I'm saying is repetitive, but the reason it's repetitive is because these are absolutely critical estate planning 101 topics that need to be addressed with your clients. And then it's regular reviews and updates. This is never a set it and forget it. Things change. Just, again, divorce, death in the family, estrangement, child becomes wayward. All of these things change on a regular basis. So life circumstances change. The plan needs to evolve. It's something we need to talk to our clients about. And, and a lot of people put this in the realm of the lawyer. Go see your lawyer. But as financial advisors, the engine of a person's affairs, their estate, their net worth is in the financial world. Yes, the legal world. And you need to have a good relationship with your clients' attorneys. There needs to be open channel communication. But I think the person that is best suited to be the quarterback for their clients in dealing with this type of planning is the financial advisor, or the CPA, more so than the attorney. I just think that, and again, and in many instances, the CPA is also the financial advisor. I'm just saying, it's a good role for the financial advisor to have, to be the quarterback. One, to do the discovery, to ask the questions, because I think people probably meet with their CPA and their financial advisor at least annually, more so than they meet with their attorney, right? I don't know anyone that really goes to their attorney unless they have to. Um, you need to keep the documents valid and aligned with your intentions. It's revisiting. What does the document say? I think that a revocable trust and your wishes should be reviewed every 3 to 5 years. And I do believe the attorney should be part of that review, but you as the financial advisor can help the client determine, does that document still meet their needs? And then ensures your loved ones know your most current wishes. It encourages participants to check their plans. Again, every 3 to 5 years is a general rule of thumb. After a major life event, marriage, divorce, birth, adoption, death in the family, financial changes, new business, significant asset growth, selling a property, law or tax changes, federal, state, estate, and gift tax updates. As I said, estate taxes and gift taxes have changed almost every other year since I've been in the business. I mean, just this year alone, we're having another change. Come January 2026, it's going to be $15 million per person. And then that's going to be indexed for inflation. And then health changes, serious illness, disabilities. One of your clients, unfortunately, they develop the beginnings of cognitive impairment, whether, there's a whole spectrum there, Alzheimer's and dementia and Parkinson's, all of those things. If your clients are starting to develop that, it's something that the conversation needs to take place on a regular basis. What's the progression? Have things changed? How are the things going to be paid for? And then professional guidance. So legacy planning involves legal, tax, financial, and emotional complexities. Again, the CPAs need to be involved, the attorneys need to be involved, the financial advisor needs to be involved. As far as the emotional complexities, I think that comes down, we're always talking about the art of discovery at C.O.R.E Group. It's about helping your client identify their vision, values, and goals, and who's important, what's important, when it's important to them. All of that is intertwined with the emotional complexities. I think a good financial advisor that's mastered the art of discovery is in the best position to help the client navigate the emotional complexities. Professionals help avoid costly mistakes and ensure compliance with current laws. Guidance provides objectivity and family-sensitive decisions. Again, your client lays out their wishes, and when the time comes for the disposition of their affairs, it doesn't really matter. Everyone can have an opinion about it. Everyone can have feelings about it, but this is what the document says. This is what's going to happen. It takes away a lot of the subjectivity and a lot of the conflict that can take place in the disposition of one's estate. Key professionals: an estate planning attorney to draft the wills, trust, power of attorney, healthcare directives. Absolutely, the attorney needs to be involved to draft the legal documents. I'm not a lawyer, and most of the financial advisors I know aren't lawyers, and the rules vary state by state. There's so many nuances and complexities with regards to the legal code. Absolutely, an attorney needs to be involved. The financial advisor has to be involved. It helps structure assets, helps title the assets to the proper accounts, whether it's titled to a trust. And by the way, one thing I did want to mention when it comes to qualified plans. So qualified plans in and of themselves avoid probate because they're a private contract and you name beneficiaries. I have seen, and I don't recommend it, but I have seen where the attorneys will tell the client to name the trust beneficiary of the qualified plan. And I get, intellectually, and ideally, I get why that would take place, right? But my experience has been, though, is that when that happens, if you're dealing with an administrator, let's say it's XYZ mutual fund or ABC annuity company, and they don't understand how to administer the stretch out provisions on a qualified plan that's named a trust as beneficiary, right? There's all kinds of technicalities, like the trust has to be a pass-through trust. It can't have a trust that retains any assets inside of it, or you lose the stretch out. There's all kinds of nuances. I don't recommend naming a revocable trust beneficiary of qualified plans, even with non-qualified annuities. it's kind of redundant. The annuity, you can name a beneficiary, you can name contingent beneficiaries. And again, when you start naming a trust as beneficiary, it gets complex. Because with non-qualified annuities, most people don't realize that you can still do a lifetime stretch out on the distributions. Most people say, oh, you either have to take a lump sum or take it out over 5 years. But under a 72Q or 72S, you can do lifetime stretch outs on non-qualified annuities, assuming that the provider can administer them. But if you throw a trust in there, it's going to make it much more difficult to do those lifetime stretch outs on non-qualified annuities. I think the tax professionals are absolutely critical. Um, the tax code is probably even more complex than the legal code. I I know enough about the tax code to be dangerous. So when we're making recommendations to clients and doing tax planning, it's absolutely critical that we include their tax professionals in the process. Insurance specialists, that's me, right? That's what we do here at C.O.R.E. We deal with life insurance, long-term care, liability coverage, um, asset-based long-term care, and annuities, right? That's why C.O.R.E does what we do. We get paid to help place the proper product to find the best solution for your client. All right, there's my commercial. Business advisors, succession planning for family businesses. Again, I think that comes under the financial advisory role and the CPA role. And then a philanthropist consultant, if the client is so inclined that they want to give money to charity, right, that's a big part of does more matter and leaving more to their community is important to them, then I certainly bringing in charitable giving specialists to help structure those solutions is warranted. So it takes a team. And as I said, I feel that the financial advisor is a great quarterback for that team to communicate with the client on a regular basis, to double check and triple check all of the things that are going on in their lives. I mean, we have to do it regulatorily, we have to do it, right? We have to act in the client's best interest. Reg BI and fiduciary standards say, we've got to be, how can we act in the client's best interest if we aren't regularly asking the client what's in their best interest? What do they want to have happen? So I think that as a financial advisor, being the quarterback of this team of professionals to help the client get their legacy together, it's a tremendous role and a tremendous value add. It's far beyond what was the rate of return you got me last year on my portfolio. So what legacy do you want to leave behind? Again, it's a question that we like to ask. Does more matter? So it's not about estate taxes. Yes, it is for some people. And, we at C.O.R.E, we work on $100 million estates, multi-$100 million estates. The planning tools that are available for estate planning and estate tax mitigation, there's a suite of solutions out there where you can get 90% of what you need to get done. It's black letter law. The IRS tells you, here's how, if you're going to do it, this is how you need to do it. We're very good at providing that type of planning and structure and coordinating with the client's attorney, coordinating with their CPA, and making sure that we get a plan in place for their reasons. But for most people, legacy planning is about preserving relationships in the family. Does more matter? If you could leave more to those that you care about without it impacting your lifestyle. Because one of the things we do at C.O.R.E is we run cash flow models. We have the client share with us what are all the resources you have, right? What is the wealth that you've accumulated? What is your desired lifestyle going forward? Use some reasonable assumptions about rates of return and inflation, and then run some cash flow modeling and say, can you get there from here? Are you going to be okay? Because that's the other thing about legacy planning is that until the client knows they're going to be okay, they don't care about legacy planning, right? I'm not going to plan for my grandchildren's welfare if I don't know that I got enough money to make it past life expectancy. So we like to show to the clients, can you get there from here? And we have a graph that we do, and the graph shows their estate. And again, the numbers on the graph don't matter. If the slope is like this, where as they live their lifestyle and with all the conservative return assumptions and aggressive inflation assumptions, and their net estate continues to grow with a positive upward slope, then they have more than enough. They have an abundance. And then the question is, if you could do more with that abundance for those you care about, would you? If they're Estate slope is flat, which basically means that they're not living beyond their means, but they're living right on the edge. Well, that's a different set of planning strategies. You still should do legacy planning. Well, you should do this 101 legacy planning, every aspect of what we're talking about here today. And then you have people where the slope is downward, which means they're in a spend down mode. They're spending more than they're growing their assets. That's a different set of, that's income planning for us, more so than it is legacy planning. But there's an element of legacy planning to keep that slope, to keep this downward slope as shallow as possible. And again, this type of legacy planning can help do that. But again, when we're talking about does more matter, is the slope on their net worth, whether the number at the end is 100 million, 10 million, 1 million. If the slope is positive, they're living a life of abundance, and you can help them answer the question, does more matter? So estate planning flow chart. 1, make a decision to do estate planning. 2, take inventory of assets and goals. Where is everything? You think about that for yourself. I asked the question earlier in the presentation. If something happened to you tomorrow, is there a person or persons? Do they know where every account is that you've got? Right? How many bank accounts do you have? How many investment accounts do you have? How many properties do you own? What insurance coverages do you have in place? Who are the companies? What are the contact information? All of that stuff. Just ask yourself that. Have you done it? We have a piece that we output. It's called the Family Love Letter, and it's a simple document, right? But it's 20 pages long, and it has lists for all of your accounts. Where are they? And you fill it out, stick it in your safe, and you tell someone where it is. You're going to need to update it every now and then. And I mean, if you just take it out and you write in pen, it's going to and it's got 95% of what it should have in it. It's going to make some people's lives a whole lot easier. So an inventory, if anyone has any interest in having a family love letter inventory package, we're happy to share it. Draft core documents, and I don't mean core, this core, us core. I mean core documents. So pardon the pun. You'd have to have a will, if revocable living trust, powers of attorney, durable powers of attorney, medical powers of attorney, health directives. That to me is the bundle that makes, as you get older, it just makes life so much easier for yourself and for those that need to take care of you and for those that need to settle your affairs after you're gone. You need to designate beneficiaries and guardians. Who do you want to get what and when? Plan for incapacity. Consider asset protection and tax strategies. Okay, now we know where everything is. I know who we want it to go to. What strategies can we put in place? Does more matter? And you start doing the forward-thinking planning. And then you decide how to avoid probate. And then the key part is if this process probably take 60 to 90 days from beginning to end, involving the attorney and the financial advisor, the CPA. Then it's review and update regularly. And the great thing about it is that once you have that inventory, once you have everything organized, you now have the blueprint for every one of your future reviews with your clients, right? Everything's laid out. And you could go down the list and say, well, what about this? Has anything changed here? How's this doing? Even the assets that you as the advisor don't have control of, you should be aware of them. And why? Because you're helping the client manage estate planning 101. So there's opportunities there as an advisor, but it also, hey, this is how we're going to do our reviews from here on out. Here is the outline. That's our presentation. It is 12:48. Again, this was the basics, the estate planning 101 presentation. The next one we will do is estate planning 202, where we'll start getting into further in depth about if more matters, how do you do more? How do you do it tax efficiently? How do you do it legally? How do you do it to liability and asset protection? How do you avoid transfer taxes for in perpetuity? Special needs planning. And again, we're going to focus on this tool called an intentionally defective grantor trust. I call them idiots. There are people who I've heard them called beat-its, idiots. And other people have their own branded names that they say they've copyrighted, but the fundamental principle behind it is the same. And we'll drill into that and its power for if more matters, leaving more to those you care about. I appreciate everybody's time today. This presentation will be available for a recording. It will be posted to our website. So there will be a replay available within 24 hours. Ryan, we were going to do question and answers. Can you help me on that? Because if I do it, I'll vaporize the meeting. I got a chat.
Yeah, the question and answer is available if anyone needs any input.
Well, thank you everybody for joining us. We appreciate your time today. Our next presentation that's planned is going to be in December, and it's going to be on cash value, life insurance, tax efficient accumulation, tax-free distribution, life insurance and retirement planning concept. Thank you very much.